Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, we are going to talk about what people are now referring to as the passing of the DREAM Act, and what has occurred, what speech President Obama gave, what the regulations are, and essentially what needs to be done in order to apply for it. Now, let me give you a little background. The DREAM Act was basically an act that was meant to help students who essentially were brought here as either little kids or babies or infants or and 8 or 9 years old, whatever it is, and they had no idea what or where they were going. They did not know that they were coming illegally into the United States, that their parents were taking them illegally, that they had no say in the matter, and they had no understanding. And not all of them came illegally, but many of them, for example, came on a visitor visa from another country and then just overstayed year after year after year. And these kids started going to school. They became good students, and what was happening is they'd graduate high school, and then they couldn't get into college because they had no legal status. They couldn't get a good job because they had no legal status, and many of them were in fact being put into deportation proceedings and deported back to a country which they essentially had no idea where or who anybody was. They didn't even know the language many times. They were basically as Americanized as one could get. And so the DREAM Act was meant to for people who fall under certain conditions, essentially for kids slash young adults, in order to give them some path to residency, in order to get their lawful permanent residency, their green card, and then ultimately they'd be able to apply afterwards for citizenship. And of course, this was a several year process. So it was going back and forth in Congress for 10 years. And then essentially last year, it was actually passed by one of the houses of Congress. And then when it got to the other house, essentially um, basically the way the politics are, the Republicans stopped it, and it was essentially DOA, dead on arrival, and it stopped again after 10 years, and after there was a lot of hope that the DREAM Act would actually pass. Well, essentially what happened is about 3 days ago, 4 days ago, President Obama made a speech, and he decided that under his authority, the executive authority, that they're going to now basically change the way that they deport people. They're going to change the priorities. So essentially, and I want to make this clear, what I'm about to tell you doesn't give lawful permanent resident status. It doesn't give citizenship. What it does is it will give a way for these students who have been here essentially and almost their whole lives, a way to essentially, number one, legally not get deported, two, legally be recognized here so they can go to college, they can get work authorization, they can then get a job, they can help with the economy and so forth. And what will happen is they will have to apply for this particular relief, and then it can be renewed if it's granted once every 2 years. And so President Obama did not make law. He didn't change law. What he did is through the executive authority that he has directed that the priorities of whom ICE deports and whom they issue notices to appear has changed. And they are going to go after people who are more of a national security risk. They're going to go more after criminals. There's only so much power that ICE has, and of the 12 million people who are here illegally, essentially, when it comes right down to it, the statistics are that they can only actively go after 4% of those people. And why should those 4% be kids who are at no fault in going out of status or coming here illegally, and are going to be able to go to college and ultimately contribute a great deal to society and to the economic well-being of the United States. So that's the background of it, okay? And even though the deferred action, that's what it's called. Essentially, deferred action means that they being ICE, Immigration Customs Enforcement, will not touch you, deport you, do anything while you're under deferred action, and you'll get a work authorization and essentially be permitted to legally be here. And so the order from President Obama is that this needs to go into effect right away. But USCIS, ICE, and the other entities that will have to adjudicate these deferred action petitions, they have 6 weeks, essentially from June 15th, in which to make the particular and procedures and the exact items that need to be done in order to process. Now, the requirements have already been stated. The supporting documents need to be provided, and then what will happen is once all of that is completed, it can be sent in once the exact procedures are sent. So for my firm, we are able to put these together essentially right now, and then if it turns out that there's something that's a little bit different, or some procedural item that needs to be in there, we'll get that in there before sending it off. But there's going to be a lot of these deferred action DREAM Act type petitions going out the door. So you're going to want to, number one, get someone who knows what they're doing, and number two, get it done before the 6 weeks so that you can be in line to get this done and to get legal status. Okay? Now, the basic requirements of the DREAM Act deferred action applications are that you have to be between 15 and 30 years old. So you can't be 31 years old and you can't be 14 years old. You get to be between 15 and 30 years old, and you have to have entered the U.S. prior to when you were age 16. Now, a couple things on this item. If you're 29 years old, 11 months, and 2 days as you hear this, I would suggest you get started on this right away, because you have to be between 15 and 30 when it's submitted. So theoretically, you could submit it when you're 29 years old, 11 months, and 29 days, and then turn 30, but as long as it was submitted prior to then, you will be able to go forward as far as the current information goes. Now, next, you have to have been present in the U.S. for at least 5 years as of June 15th, 2012. Okay, so if it's 4 years, 9 months, and 20 days, then you're not going to qualify. There's no way around it. Okay, you have to have that 5 years. Now the question becomes, what do you prove that you have been here for 5 years? And also the first one, what do you prove that you've been here since 16? Since a majority, a large amount of applications will go forward will have come here illegally. So there has to be supporting evidence to prove what they're asking for. And I can tell you from all the years of experience I have in immigration, it is likely that if it is not sufficiently proved, because it is your burden, it's not immigration's burden to give you deferred action, it's your burden to prove what they want here, and then they can give it to you. So, what my firm does when we do these types of petitions is we get declarations and affidavits, we get all kinds of if there was Social Security statements, work statements, school records, all kinds of stuff, airline records, um, receipts. There's a wide variety that can be used in order to prove what needs to be done. And that's for both of those items, whether you entered before 16 and have 5 years of physical presence in the United States. Now, you have to have maintained continuous residence. So, there's issues on what exactly that's going to mean, but obviously you can't have come here to the U.S. 6 years ago, left for 4 months, come back for 5 months, left for 3 months, and then it depends. I mean, the time that you can leave and have come back will depend, and I suspect in the future there might be some litigation on what continuous residence means. But obviously, if you came here and never left, then you have no problems at all. But if you came and left and came and left, I would think it's still possible to make some good arguments, but the case will be more difficult. Now, next, you have not been convicted of a felony, a significant misdemeanors, or multiple minor misdemeanors. Now, here's where a lot of people are going to get caught in the fray and not be able to qualify. Felony is a crime that has a sentence of a year or more. Essentially, that's how they've defined it. And then, as far as a significant misdemeanor in the regulations or in their memo, as they've defined it, it includes a lot. I mean, includes things like DUI, simple assault. So there's a lot of little crimes essentially that you may have committed in the past that might kick you out of here. However, there are ways to get around that. There is possible. You come to my firm, we can do a motion to vacate. We can do a motion to reduce. We can go back to criminal court and try to do what's necessary in order to make you so you're eligible for this particular relief. So just because you might have the crimes doesn't mean you should just immediately give up and say, oh, I'm not going to be able to apply, because there are ways to work with those crimes so that if it is properly changed, vacated, amended, or reduced, that you'd be able to go forward. Now next, you have to be currently in school, graduated, or have a GED, or you are an honorably discharged veteran. So, again, we have to prove any one of those elements, and that really will probably be one of the easier elements to prove, because if you're in school, you're just going to provide a curriculum that you're in. If you have a GED or graduated, you provide the certificate or the GED, and obviously if you were an honorably discharged veteran, you'll have papers to reflect that. Now, the deferred action is not only available to people who are not in removal proceedings, but it is available to people who are in deportation proceedings right now. Okay, it is also available to people who have a deportation order. It may also be available to people who have been deported, but may still qualify under this, and we can do various motions to reopen. I mean, they've made it fairly wide open to be able to get the relief you need, and that's why it depends on which agency and which forum you would file, and that does depend on where you are in the system, whether you've never been in the system, whether you're in deportation proceedings, whether you have a deportation order but are still here, whether you have a deportation order and have been deported. So it does depend. So what I would do is contact my office. Give us a call, give me an email, whatever, and I will be able to give you a consultation in order to see if you qualify, in order to see if your family qualifies, anybody in your family. You have to be aware, though, there are certain risks to family members. For example, if the kid qualifies, but the parents are here illegally also, which is a lot of the cases, there's no derivative benefits to the parents. Okay. However, there is prosecutorial discretion to not put the parents in removal proceedings, and there's petitions that can be done too. So you have the ability to take advantage of the situation And I would strongly advise to get a consultation and not maybe sit back and say, well, if my parents have some risk of being put in removal, I'm not going to go forward. Because remember, ultimately, if you go forward and eventually, if some laws finally come out that let you get residency and citizenship, you can petition your parents. If there's a form of relief that you qualify for, then you should go for it. So give me a call and I'll see what I can do to help. More on the coming videos.